So I just thought I'd do another video about the problems with this Petitions Committee staff and the Clerks of Parliament in the checking of the petitions and the acceptance of them and the publishing of the petitions, right? So if you learn about parliamentary agents, there are about 7 or so parliamentary agents. Not many law firms have a parliamentary agent. It's a service that isn't as available. Now, these parliamentary agents, they have Role A, Role B and Role C agents, and they're members of a society, right? Now, the reason the society was formed is because in early modern history, or in the history of Parliament, the clerks of Parliament used to actually have a sideline job, a little cushy sideline job, right? When they could get agency work. So what they would do is businesses, private individuals, companies, right? And this is before these huge corporate entities. I suppose you had those railway companies, you had, you still had factories and so forth. But people would pay the clerks of Parliament, right? They've got various clerks. They aren't just Goldsmith and Burton, right? There were various different clerks, right? There's Journal Office and so forth. They would pay them to do some work for them, right? Private employment. And they would pay them to help them prepare private bills and so forth and to submit them, right? Obviously, like you got sponsored and unsponsored bills. The government sponsor most of the legislation, the political parties and so forth, right? But you can put private bills, right? Now, so the clerks used to actually, have a little cushy job, getting paid money. Now, this practice, they put a stop to it. They ended the practice, and instead, they said that people have got to get their parliamentary agency from private firms who aren't anything to do with the Parliament staff, right? So now so they formed this Society of Parliamentary Agents, and that's why we've got them. So there aren't many people who do it. There were only a handful of companies, but you can also have a parliamentary consultant. That is someone who you can consult about parliamentary business. Now, the thing is, right, back in the 1800s, so if you look at the history, and if you look at a graph of history, like a diagram or graph of history, right, the petitions to Parliament are not that numerous, but then when you get to the 1800s and the period of the Luddites and the factories starting and the Reform Act and the suffragettes, you get this massive peak and then it goes back down again after. Now, we don't have all of the petitions because they were all destroyed in the fire, so we're told, right, of 1834. Now, those documents are very important because those documents, the ones that had over 20 signatures, would have had like a seal on them or a stamp from the court where they got consent. And they would be a little bit like sort of probate documents now, wills and probate. When you get wills and probate, you have a document and it's got like a wax seal or stamp on it of the court, right? Because it's an official document, a very important document, because it proves ownership of lands, goods, buildings, houses, and things like that. Now, the petitions to the House of Commons would need, up until 1985, needed to be approved by a court, and that's really important because it would be officially it's like a court order. I don't know if they would have a separate court order as well, when you come out of court with a document, an order, or if the petition itself with the stamp and seal on it, similarly to the probate. Now, they were doing the you've got the really old probate documents with a big heavy wax seal on, right? Some of them would just have the stamp on it, or the Commons or the Lords or whatever, but for the courts. Now, those have been destroyed from everyone before 1834, except for a few very rare, obscure specimens, have been destroyed. Some of them and local petitions have like signatures of constables or signatures. The judges just sign them, right? Some from the local courts. Some appear in the newspapers. So anyone that got put in the journals of Parliament, but it doesn't. The journals of Parliament don't tell you how many people signed. Those are on other records. There is a record of data from petitions, but it's only data. It's not. They're not the original documents. They're not the original articles that people sent in, right? And also, Parliament continued to destroy the original petition documents themselves, the articles, up until apparently around 1947. So that means that all of the original petition papers that had these seals and marks on and things like that, very similar to a probate document that had been ordered, they wouldn't have it if it was under 20 signatures, because you're not attaching more than 20 people to the petition. What it does is it grants privileges to more than 20 people. It means that that petition case cause is allowed to attach more than 20 people, and also privileges to more than 20 people. And that's the thing, under 20 people could have it automatically. And from 1688, the Constitution grants you it. You're granted it automatically by the Constitution. You don't have to ask anyone for that privilege. You get it. And this is the argument in this paper when Jacob Rees-Mogg and crew, these 12 ministers in this e-petitions document, are trying to persuade us and lead us to believe that we're not entitled to privileges for petitioning, or at least not until way after it's all done and dealt with, or only in the chamber, which would mean that, they're wrong, of course, completely wrong. History and law proves them wrong, but it would almost be like, the guy who sells the newspaper and publishes the newspaper and walks around shouting out, advertising the newspaper and reading out the story has got more privilege and protection than the people who are collecting the signatures to get it in the first place through to Parliament, which would be preposterous. But that's what Jacob Rees-Mogg and this committee are proposing, right? They clearly hadn't. They're not well read on it. And they didn't. They're trying to completely ignore and omit the law of parliamentary agency itself, which is well known to include canvassing as a particular thing to which incurs agency, right? But anyway, I want to come away from privileges a little bit and back to these clerks, right? So you can have a parliamentary consultant. Now the thing is, if you read the petition archives of all the transcribed petitions that Brodie Waddle has transcribed, he did it during the pandemic, right, with a team. They transcribed them all. I haven't read every single one of them, but I've read all the ones that are connected, anything that is to do remotely connected towards privileges or protections, right, which is like a few hundred of them, right, because there are thousands of them, right. I would like to read all of them, but some of them are from local courts. They're not actually to do with Parliament, right. Now, the fact that they didn't have grammar schools and they didn't have public schools, and 60% of men in 1800 were literate and 40% of women, right? Now, that is the most important factor in this argument about getting petitions submitted and accepted, right? Because as they said in the standing orders and resolutions, right, Parliament can decide how fit they are to be received, right? How fit are they to be received? Now, that statement has to be interpreted in the context of the 1617 and 1800s, when very few people were literate. And of the ones who were literate, not all of them were literate to a high standard, right? So, people who couldn't read and write had to ask someone to write the petition for them. But they weren't stupid, they could talk, and they might be intelligent, but they just might not have been able to put it in writing, okay? They can ask for something that they want, and then they know they know that they can ask for it. So they're not that stupid. It's not like you know, they don't know anything about Parliament or anything, you know, what the government does or whatever. You know, to put it this way, they were a hell of a lot more literate about life in the 1800s than what we are now. They probably might have known a lot more about how Parliament worked back then and what you can and can't do in it than we do now, right? Even when we've got books and things, right? You know, they knew a lot more about the life back then. And, you know, this is all about complaints and grievances anyway. Now, so approaching a solicitor, lawyer, or agent, or a friend to write something down on paper for you and spell check it, and then get you to sign it or put your mark on, even if you could or could not write, that is the main principle of how fit these petitions are to be received. There is no doubt about that. Now, obviously, you know, they need to, you know, not have swearing in or, you know, foul language or whatsoever, and it has to be something the government can do. But people aren't that stupid, right? And when we get to this argument about, you know, what can and can't the government do, let us be under no disillusions at all. In the paper, which Jacob Rees-Mogg and 12 of the committee altogether worked on, this document for e-petitions, right? They say in there, they make the paragraph and statement and claim that e-petitions should make use of every single committee and every possible function and use and department which is available in Parliament. It should make use of every single possible avenue of redress, right? So that's what they said and typed and wrote this committee in its report, right? So that extends to quite a lot of possible things that you could get the government to do if you wanted. And let's not forget, you know, Boris Johnson, as Prime Minister, used to go and shave sheep and pull pints for a bit of publicity. That's something that he can do. Can you come to my pub and pull a pint for me, Prime Minister? Although it's not meant to be for sponsorship or promotion. But if that doesn't sponsorship or give promotion to a pub, I don't know what does. You know, it's just meant to be the Prime Minister going about doing his business, right? Now, at the end of the paper, on the review of the Petitions Committee, they then say that, oh, by the way, we don't want anyone to petition about any honours, right? You know, removal or granting of honours, because there's a special process for granting honours and so forth. But this is the thing. There is a committee for forfeiture, right? And if someone like Tony Blair or Jimmy Savile or whatever has done something wrong, why not? The thing is that honours people used to vote. They used to elect knights. You get a knighthood through election. You elect knights. That's the tradition of it. So it's voter based, right? Honours, not like the Prime Minister picks them out of his back pocket or whatever, right? The magistrates, the sheriffs are all meant to be elected. And the jurors, right? The jurats, the permanent jurors. In America, they have a lot more electoral positions still in place. But over here, we don't anymore. Not the police chiefs. They brought it back in a little bit with the mayors and the police and crime commissioners, right? These people, we elect anyone who you elect, like a mayor or a police and crime commissioner or whatever, can be removed through electoral power, right? Because if they're not performing, why would you want them in there, right? Now, that's the basis for honours as well. It's going to be what the people want, although the king can grant them and so forth. But you've got the right to petition the king, right? Now, they're trying to protect themselves. They're trying to obstruct and deter us from being able to petition about something which is a function of the government. It is a acting working committee. And they said that they want to utilise all the committees, every single one of them, right? So immediately in that paper, they've already contradicted what they said. They've said that you can utilise the whole of the government and every committee, and then they've gone completely opposite, and they've said, no, you can't have this committee or that committee, right? So when we come to arguing and disputing with these Petitions Committee staff, these 4 people or however many it is, who, by the way, in that paper they say they want to pay them £200,000 a year, and there's 4 of them, so they claim, right, in that paper, that's £50,000 each, and that I worked out it's about £900 odd a week, right? Unelected, getting £900 a week, and they're not even getting through all the petitions now. You have to wait months, and they get rejected anyway. Now, what they've actually created is an impossible position, right? Because the e-petitions committee, the rules of the committee I've discovered are merely a policy and agreement, and it's signed by the leader of the House of Commons and the chair of the Petitions Committee, and it's not based on any law. It's not really based on any resolutions or standing orders. It's just based on a committee, recommendations and stuff they've just decided that they want the policy to be, right? Not really any law. And they're trying to get us to when you do petitions on that website, that's a policy, right? But it's just pulled out of the pocket, right? Which I thought it was all along. And a lot of it's unlawful and illegal. Now, they've said that in the policy, the 4 staff members do not have to enter into discussion and debate whatsoever at all or respond to any challenge over their decisions, whether or not they made the right decision, whether or not it was factual, whether or not it was right. So they potentially can reject your petition and claim any reason at all. They can claim any excuse or reason, and no matter how, if it's not true, if it's not even factual, and if they're wrong, you can't argue with them or debate it. So it's an undebatable position which you cannot have redress to, and they can potentially reject every single time. There's nothing stopping them doing that, and you cannot really do anything about it. So This is the dream. This is an absolute dream job position for a Labour or Conservative person. This is the partisan's dream power. Not having to answer to your opponent in debate, discussion or contest, and being able to do it every time. Permanently block them. This is the dream power. It's almost like a dream come true for any Conservative or Labour. Now, if they shook hands on that and then therefore they're blocking every single independent person who opposes them, it's a political superpower. If the Conservatives could have that power against the Tories, they'd be laughing. They could just block them every single time and not even have to debate it or argue with them. It's parley. Parley is to talk. To come and talk and debate. So they've invented a position, a new role of possibly 4 persons, so it alludes to in the paper, who are on up to £900 a week, right, who can permanently block you and not be accountable to redress, right, or debate. In Parliament, the place to talk. So you can be permanently blocked for no reason or any reason, right? Now, if that isn't creating a new privilege, I don't know what is. They're not allowed to create new privileges, right? But that's a new privilege, I'll tell you that. And at that stage, right, and this is not the law, by the way, right, in the paper, Jacob Rees-Mogg and his 12 honchos, his select committee cronies, right, they're attempting to convince us, they're attempting to persuade us, and it's nothing more than that, it's nothing more than a persuasion and an attempt to deceive, that privileges shouldn't apply to petitions. But seeing though that it's a paper about e-petitions, we'll do two pages on privileges, like it's not got anything remotely to do with it, at all, but we'll do 2 pages on it, seeing though, we're talking about e-petitions, right? So they attempt to convince us that privileges aren't related to or connected with or used in the preliminary proceedings of petitions and are only relevant inside Parliament and after they've been published, right? But yet then again, the paper boy can go around shouting it out in the streets, read all about it, extra, and not be prosecuted outside Sadiq Khan's house. But the people who were collecting the signatures won't be able to do that, right? Which is preposterous. And that persuasive argument, that attempt to deceive us is not even actually, I don't think, put in the actual policy. It doesn't appear in the policy as a policy clause under the agreement. When they do the agreement, it only appears in the paper as part of the review and assessment, right? With persuasive argument. So, they don't actually definitively say you don't have any legal rights to privileges for petitions, and why would it be irrelevant? Why would you put it in 2 pages in a paper on it, if it's got nothing to do with the process, right? So there's that. So these 4 staff and the Clerks of Parliament, the staff are making use of parliamentary privilege and exerting a new privilege of not having to enter a debate or discussion with you about it. Well, what happens if your MP just never replies to you ever or puts it on auto-respond, you might have an MP that you don't get anywhere with, so, many people give up, maybe they just, this is the thing, by the time you finish, they just think, we're fleecing you that much that, we might as well just, finish off the job, they're deceiving us and conning us that much that it's not much of a big deal anymore to deceive and con, and that's, I think, what they're doing with this, right? So these staff members are using a newly created privilege, which is not created by standing order, not by resolution of Parliament, and not by a statutory instrument, not by an act of law, and not by the Constitution of England. It's created through a policy agreement, right? Recommended by a committee and signed by the leader of the House of Commons and the chair of the Petitions Committee. You have got to be kidding me. Consent, submit, accept, if you want to use this website, right? Consent, submit, accept, right? That's almost like this Section 240 in America, what they're doing under the, CDA Act, for removing everyone's stuff from YouTube, which they did to us all in England under the pandemic anyway, right? Or they did to Americans. I think they tried to make out they weren't doing it to English people, the 77th Brigade or whatever. So they're acting with a protected privilege, are these people processing the petitions, at a stage in the process where they don't think that we should have a privilege. The people who are actually the ones who are eligible, the ones who are meant to have the privilege in the Constitution. One clause in the Bill of Rights about petitioning, it could be that, petitioners must, wear a red hat. Could be that petitioners must eat a bacon sandwich. Could be that petitioners shall, sit on the floor. No, it's one provision and one only, and that is that there shall be no prosecutions or put in prison, and that is explicitly and specifically privilege, right, and nothing else. So why that won't be applicable to petitioners on e-petitions, I don't know what planet Rees-Mogg is living on, right? So. But they're trying to persuade people that it doesn't exist, which they can't possibly do if you take into account the law of agency, canvassing, and the entire history of England, right? And the Parliamentary Papers Act, he throws that in there as well, and tries to make that certainly relevant afterwards. And then you could have the newspaper stand. You could have a load of newspaper stands outside Sadiq Khan's house selling him the newspaper that says "Get Khan out." After Parliament have debated it, after Parliament have debated "Get Khan out," then you can send your newspaper boys around and have a parade outside his house going, "Get extra, read all about it." According to the Parliamentary Papers Act, a newspaper can, the effects of the newspaper can't be legally challenged, right? But not the people who are going around collecting the signatures. This is Rees-Mogg's logic, right? The logic of Mogg, which is illogical, right? And then another point that I made is that, in the Manual of Procedure of Business for the House of Commons and in the Erskine May Parliament usage of Parliament book, right, it says that anyone who writes a petition, right, and collects signatures can post it to Parliament free of charge, right? So that means that you've got the privilege in use, in effect, right, from your house of not having a charge against you by Royal Mail for a delivery of a letter to Parliament before they've even read it or looked at it, right? So you're given a privilege to get it to Parliament, right? Before they read it and decide whether it's acceptable or not, right? So that is another strong piece of evidence that Jacob Rees-Mogg and his, 11, 12 cronies in this select committee are talking absolute, pure, unadulterated tosh. And they're not fit for position. They should all have their titles removed through forfeiture, So that's another argument why the privilege must be in effect before. And even though it's e-petitions, and on an e-petition you do it online, like you can go to a local library if you don't have a computer, that's free. Sending an electronic communication is free. You don't have to pay for it anyway, But it's the symbolism in it. The symbolism that what Jacob Rees-Mogg and his cronies are trying to do in that select committee is persuade us and lead us to believe that even if it wasn't e-petitions, even if it was paper petitions, then there might not be such a thing as privilege that anyone would have or make use of in the preliminary processes of petitioning, in the preparation and canvassing of them, that it doesn't really exist or apply anyway, so why should we apply it to e-petitions? Even though such a thing clearly does exist because we're writing 2 pages on it, and we're going to say that it can apply, after it comes back out of the printing machine at the back end of Parliament, right, and ends up in the newspaper, right? And then you've got all the legal cases over that. So, I didn't really want to get too much onto the privileges part because I want to keep this about the clerks and the staff, right, because it's about the checking of the petitions. So, but the privilege definitely, there are privileges before it gets checked and read. Okay, and we've got privileges, but they're saying we don't, but these members of staff do. And it's like, can you imagine that in parley, in the place of talking, the place of debate, they've managed to conjure up a little secret chamber or room where there is to be no debate. You cannot, it's undebatable, it's unarguable. That has to take the biscuit. I don't know how they managed to conjure up that, how they managed to get it put through Parliament or checked. And it's not even, they didn't have to get a standing order for it. They didn't have to get a resolution of Parliament for it. They didn't have to get, an act of law put through or a bill, and didn't even have to get the constitution changed. They just came up with a policy and they just said, this is how we're going to run it. And it's signed by the Leader of the House of Commons and the Chair of the Petitions Committee. With our powers combined, we are Captain Planet, right? Consent, submit, accept, right? Kneel before Zod, right? You got to be kidding me, right? Now, so you're not allowed to, when it's rejected, you're not allowed to debate or discuss it any further. But they will make a recommendation or even provide a suggestion of maybe how you should write it. But apparently they can't understand what you're asking for. But here's an alternative that you could have, which is literally, asking the exact same thing in different writing. But they wrote it, not you, right? Or why don't you do this? So they're telling you what to write and what to do. Now, this is the part that rings alarm bells for me. Can you imagine a Conservative Party which could block every single thing that the opposition put forward? They didn't have to debate with them, right? So can you imagine, right, Keir Starmer Labour Party, who could reject and block every single thing that the Tories proposed? They didn't have to enter debate into them about it, and they could block them every time, right? And they could say they didn't have any privileges, and also further than that, they could even make them suggestions. Well, you shouldn't be asking for this. You should be asking for that, right? The Conservatives, propose this law and say, well, why don't you not ask for that law? Why don't you ask for this law, right? But by the way, this isn't the debate, right? This isn't the debate. This part isn't the debate because I haven't even accepted it yet. I'm not even going to let it get into the building to be debated because I'm rejecting it from the building because it doesn't comply with our policies, right? But if this was a debate and if I were debating with you, I wouldn't debate it with you, right? That's where it is. It's pushing it out, right? You don't even want it to get in. So, it's a power. What they said that you can't create any new privileges, and what those 4 staff members have been given and what has been created through a mere policy agreement, right, between 2 members of parliament only, signed by suggestion from a committee and nothing more, right, is that, they can tell you what you should be asking for and how you should be writing it. Now, that is not the role of the Clerk of Parliament or the Journal Office, and it has never been, right? The role of the Clerk of the Journal Office of Parliament is if you want to ask them for advice, if you don't know anything about government, if you're like clueless, if you're like, a tourist, like some kind of, foreign tourist who can't even speak English, take photograph of the London Bridge or something, right? Read the information sheet, right? If you don't really know about Parliament, but you want to do a petition, you can go ask them for guidance and advice, right? If you want to, if you need it, right? Like there's parliamentary agents, if you need it, right? You might not need advice or guidance, right? That's what they're there for, if you should want it, right? And, people who are putting bills in, private bills, they were paying for that advice and guidance. They had to pay for it. They didn't get it for free, they had to pay for it. But they banned it, they put a stop to it, right? They ended it. So why haven't they ended clerks meddling with petitions? Seeing that every single English citizen nearly goes to a private school or public school, is educated and literate, right? The petitions are fit to receive, right? Because we've all got a keyboard with set letters and you don't have to, write it clearly or neatly, and you don't even have to sign it, right? That was the main part of that. That was over 50% of the issues with the written petitions. What is being referred to in all those standing orders and resolutions, right? And so therefore, when you've got a keyboard and you can type clearly, and when you've been to school and you're not a retard, right, then there's going to be very few problems. Now, the thing is, they've got problems in the paper because they're saying, you can use you can use any committee in Parliament. We want to have this e-petitions to utilise every corner of the government which is available, right? This is the basis, right, of what they're doing. But then they say, but you can't have that. So it's like, you can have anything that's available. Anything that exists in the government that's available, you can have it. And then they go, but you can't have that, right? But that's what they're doing. And with that attitude and with that initiative, this is how the Petitions Committee have moved forward. Right, so you write a petition, you say, I'll have this or this, I'm not retarded, right, I know there's this department and there's that department, and this, and then you write it, and then you go, but you can't have that. And that's what it is. It is, you can have anything you want, but not that. And that's what they're doing now. This is what these 4 people, unelected, on 900, possibly up to £900 a week, 4 of them, right, on our taxpayer money, right, and now running a petitions committee with fully literate people who can read and write, who many of them are not using swear words like, the F word, the B word, the C word, right, or whatever. Not using swear words, right? But now any word can be offensive depending on how you implement it according to this government, right, Not using any swear words, right? But, right, but you can't have that. Anything like, but you can't have that, but not that, right? And there's no redress. There's no redress. Our decision is final. No dispute, no argument, no redress. In a place called parley, which is to talk and speak, right? And effectively, they can potentially do that every single time, right? And you have to go collect 5 signatures again, go collect 5 signatures again, go collect 5 signatures again, go collect 5 signatures again. But you can have it how we want to write it. Now, this part of it, when they say, oh, why don't you write it like this, why don't you write it like this? It's the same thing, right? Now, it's beyond grammar. It's beyond literacy. And it's beyond knowing what people are asking for. They're trying to write it for you, right? And that is not a petition from an individual. It is something written by another person, not you, right? And if it's written by a person who's your opponent or secretly your opponent, partisan, then it's like, I'll tell you what, why don't we get the Conservatives to write all the Labour policies, right? Why don't we get all the Conservatives to write all the Labour policies, and we'll get all the, Lib Dems to write the policies for the Conservative Party, right? But when they're all in agreement on a lot of things, then it's like they are one party. So it's this new juggernaut of a little committee. It is the most... it's impossible. It can't possibly constitutionally exist, but yet they made it. It's founded on no legislation. It's founded on no laws, no acts, no bills, no standing orders. Well, there's a standing order creates the committee, but not the staff, right? And then the other thing is this. How can you complain about it? Well, back in 2013, 2015, I didn't think about complaining to this procedure committee or to the standards committee, because I thought that you just complain to the Parliamentary and Health Service Ombudsman, because it's called the Parliamentary and Health Service Ombudsman, so why wouldn't you complain to them? But apparently you can't complain about MPs. You can't complain about elected members. But when I read this paper now, it turns out that the e-petitions website and facility is co-owned by Parliament, the government, no, not Parliament, the government and House of Commons. It's co-owned by the government and the House of Commons, right? And the staff who run it and so forth. Now, you can complain to the Ombudsman about Parliament, right? But not about ministers, because they have to be, because of their privilege, it has to be like the Privileges Committee or, like the Committee of Standards, right? But those, we don't elect those staff. Now, back in 2015 or whenever, when I complained to Barry Shearman, to Ombudsman and so forth, the Ombudsman was saying that, we've checked and we don't know anything about Petitions Committee. We don't govern it, right? Well, I don't think they were fully or properly educated or read on it, because it says in that paper that, which I don't think that they've read, that it says that it's co-owned by the government, right? It's co-owned and operated by the government. Now, the website is apparently managed from the Leader of the House of Commons' office, right? But the website is owned by the government, partly. So I believe that because it's co-owned by the government and co-run by the government, that it's within their remit. And I believe that you can complain about those 4 staff members, about the atrocious way that it's been run, about the ridiculous policy, about the impossible policy, about the denial of rights and the lack of support for rights and the lack of support of privileges and assistance and backup in a legal proceeding, of which it is. And you can complain about it being rejected on a ridiculous clause, because what they've done with that policy clause, this has got to be the most genius. It's the most genius policy that the government has ever come up with, and they didn't have to get it voted through Parliament like a bill and approved by the Lords to assent, right? It's not even a standing order or even a resolution. It is merely Jacob Rees-Mogg and a few of his cronies, right, sat in a room procrastinating, coming up with some absolute pure tosh about the law of rights and privileges of England, being completely ignorant to the entire law of parliamentary agency, right? That it doesn't exist. When, there are books on it, right? And Herbert Broom and Erskine May, a large amount of Erskine May being ignored, and naively and rather, just purely ignorantly, right? Attempting the best attempt that they can come up with, right? To try to absolutely and completely Billy bullshitters, right? And mislead us and lie to try to get us to believe that we don't have any privileges for doing e-petitions, or that we shouldn't. Yet, when it comes to putting the policy down, that doesn't appear in the actual policy, right? It's just in the paper, right? It's not in the policy. It's not in the agreement. It's just in the recommendations and assessment, right? So this is the mentality of MOG, and this is what they've invented and created. It's in the flavour and taste of this whole pandemic lockdown principle. It's in the taste of this Digital Media Platform Act and the Section 230 the Americans have done, right, where we can just take anything down for any reason or no reason, and you've got no constitutional rights. And it's in that flavour and taste and trend and in the mechanisms of implementation which follow from that, and it's completely and totally illegal, right? And it's not the people who are operating it, we didn't elect them, and they're asking advice from government departments which we're opposing in the complaint and grievance, right? And then they're saying we can have and use any available thing, but not this or that, which they're picking random committees out, which they say they want us to use all committees, and then they're picking out random ones, oh yeah, but not that one or that one, right? So how can you proceed and deal with such people when even in their review paper, they're coming out with this type of thing, like paragraph, this paragraph, we really want this Petitions Committee to utilise every committee possible and all corners and forms of government, right, which are available, to utilise for these petitions, right? But then at the end, but not that one that, not that forfeiture one that, could take away, the knighthood of, Jacob Rees-Mogg or whatever who come up with this, right? You talk about self-preservation. Never mind their privileges. They're even extending their privileges to cover committees and obstructing us from access to certain committees through the process. So what they're doing, they're actually reinforcing their own privileges, and then they're saying you can't talk about this or that. And this process is fully protected in the law. That's why the Parliamentary Papers Act is there, so there can't be any criminal or civil charges against anyone, and when they need to bring important matters to the government. And all this has been thoroughly discussed through the 1837, 1838. It's been meticulously debated in detail, that the legal principles behind possibly these things getting in the newspapers or, slanderous accusations, it's all been milked till there's no milking no more. They've debated it down to the decibel, right? It's been debated, cognised, thought about, and ironed out like it's been ironed out like a pancake, right? Repeatedly to make sure that it's right. And then they put an act about it. And then there's MOG and cronies in this paper kind of like nitpicking at it. Well, no, that's done and dusted, that part. Oh, well, maybe you shouldn't. No, But yet they're implementing reinforcement. It's almost kind of like they're reinforcing their self-preservation, right? And then saying that we haven't got any protection at all whatsoever. None. Now, the whole point of Parliament is to hold MPs to account, like through election petitions, which you can do in Parliament, but they put it into the courts, right? You can't hold MPs to account in any place out of Parliament. You can't hold MPs to account in a criminal court. You can't hold them to account in a civil court. You can't hold them to account in a tribunal. You can't hold them to account, in Ofcom. You can't hold them to account in all these places out of Parliament. If you want to hold MPs to account or the government to account, it has to be through Parliament, into Parliament, because they can only decide their own matters. So the complaints have to be to and through Parliament. So any complaints about MPs, how committees are run, or anything like that, must be through into the Parliament, except they've also got the Ombudsman, but that's not for MPs, remember, that's just for Parliament and the government generally, not for the MPs themselves. So there's no other place for redress for it. It has to be at Parliament. The redress has to be at Parliament, because we can't get redress at the courts or county courts and so forth for the matters that Parliament are the adjudicators for. It has to be brought to them. But they don't even want us to do that because it affects their reputation. Well, the only person's reputation that it affects if you make a false claim is the person making a false claim, because it's not true, right? This is the thing. But they don't even actually want us to be able to petition about the elections, about their conduct of behaviour, about forfeiture, anything like that. But yet that's the place to do it. So they've completely, it's one for all and all for one. It's all for them and none for us, because they don't want us to beat them. And when they're cheating and breaking the rules, we can't do anything else about it out of Parliament. We have to send them the complaint in, and they have to look at it and then say, act on it. But they don't even want to do that. They don't want to acknowledge it, and they don't want it aired. And unless you can raise awareness of it and have the public put pressure on the government to act on it, which is what you do by the signatures, and compel them to debate it, you won't get a redress. But remember, our signatures and our awareness of something that the government might be doing wrong, right, is not it's asking for it to be questioned in the Parliament, right? And if you ain't got any pressure on them, they'll just ignore it. So, that's the interpretation of it. But the fact is now that the very knowledge of it is defeating, because if you're right, and people find out about it, it's more difficult for them to hide or cover up. They have to start lying and blagging and misleading, like with this Call a General Election petition. And this is why the Prime Minister now, he won't answer any questions, because he can't afford to answer certain questions, because, it can harm his policies or government. So it's all become a stage show. And this is what Dominic Cummings is talking about with his, scripted meetings and so forth. They're not actually accountable. They're not accountable in debate, because if their opponents come out with a strong or powerful question, and then it doesn't have to be answered, because the answer to it can, the answer is, the correct answer, obviously they lose, right? So they don't even want, they can't answer a question, even to their opponents. And that's kind of like when they reject your petition and they don't want to enter a debate about it. So, it's evasive, and it's not parley, it's not talking about things. It's the art of not talking about something. So what Parliament has become, it's become the place of not talking about things, of not debating things. It's become the place of scripted plays, of, waylaying people, of, filling in the time with a load of jargon and tosh, so then you can just go and do what you bloody well want anyway afterwards, right? And regardless of what people think, say, or debate, right? That's what it is becoming, And the thing with these petitions is, I've read some of the rejected ones, the ones that they want to publish. Obviously, there could be some with swearing in and things like that, which they don't even want to publish. But of the ones which were officially rejected, every single one of those, I think there's a department that can deal with it. Every single one of those, I can perfectly understand what is being said, right? And when there's no redress, there is a process and procedure for appealing a rejected petition. And it appears in the Manual of Procedure or Erskine May, but there is a process for it. It appears it's on record. It does exist. It's possible to appeal it. And you've always got that bill of exemption that you can put through to the King anyway, from decisions. It's meant to be put through to the King from any court. Erskine May clearly states that Parliament is the High Court of Parliament, right? So, if they reject something and you're arguing them about your right, then you're meant to have those bills of exemption which can be sent to the king, and they call them up and, get all the facts out or whatever, particularly if it's the speaker. Well, the speaker's meant to be responsible, isn't he, for decisions of parliament, or one of the committee chairs, one of the chairs of the committees that, it's equivalent. If the committee's dealing with it, it's the chair of a committee, should be summoned to the king or whatever. But anyway, so... essentially, this talk really was supposed to be just about the role of the clerks and these staff, and that is that when people who can't read or write used to have to get a solicitor or someone to write their petition for them because they couldn't or they didn't really know too much about it, they wanted help, right? And the clerks could do that, but the clerks were doing that for money, for putting private bills through, but they put a stop to it. So I think that we need to put a stop to this clerks deterring and intervening in petitions because it's contemptuous. They shouldn't get involved with petitions, Clerks don't get involved with legal cases in courts. When you go into a court, right, the clerk, half the time now, they say, I can't talk to you about it, When you ring up a Crown Court now, they will not enter into any dialogue or talk about anything, right? Not even giving advice how to submit a case. So I don't know how the Clerk of Parliament can give advice how to submit a petition now because the courts won't do it anymore. They used to, up to a certain extent, not anything that doesn't qualify for legal advice. They could tell you, they could give you forms that they've got, what form do I need or whatever. If the county court and the criminal court cannot give any legal advice at all whatsoever, then how can Parliament? Well, you might say, because Parliament's democratic and we don't have to pay for it, right? Well, but the reason for that is because it is political, but that's the problem, the clerks now have got agendas, like Malcolm Jack and all these other clerks who writ the Erskine May books, I don't think that we need advice for petitions really, unless you're that stupid, then you don't really have a clue whatsoever. But it's almost like the level of, tourists coming around taking photos, it's like, American tourists coming around, me take a picture of America or whatever, London Bridge, Tower of London, it's that touristy kind of like level of intelligence where, have you got a brochure for the House of Commons, it's almost like getting a guided tour and here's a clerk, we'll do a petition, I'll give you some advice on that, This is the thing, not people who are actually engaged in politics who don't need any advice. And mainly, I actually believe that, how are you going to see the clerk in Parliament anyway in like 1750 or 1850? You're not going to be in London. You're likely going to give it to your MP or send it in. Now, your MP might give you help to write it, but only as much as if you got like a solicitor. And those solicitors, what I wanted to say is that the role of the parliamentary agent or the parliamentary consultant is kind of like what these petitioners were getting. So like through 16 and 1700s in the archives, those petitions when people didn't write it themselves or whether like, only one person wrote it and the rest of them just signed it to put their mark on it, that would equate to parliamentary consultancy. So there were probably a lot more lawyers and solicitors around then who you could consult, parliamentary consultants or parliamentary agents in the sense of helping individuals with petitions. But now there aren't any at all. You're viewing up these parliamentary agents and parliamentary consultants. They don't deal with any of the public. It's quite a rare occurrence for them to ring up and want help with a petition, right? But there used to be, because people didn't used to be able to read and write, okay? But so when they say the parliamentary consultancy and agency is a new thing since they stopped the Clerks of Parliament taking on a lot of work, I think what they mean to say is that, for businesses or for private bills, because I think they were parliamentary consultants, or what we would call those, when people were illiterate, because a lot of the lawyers would help them write it up, just like they'd write a legal claim. But now everyone is literate. And it's not that difficult to work out. It's not that difficult to work out that it's something that the government can do and within their power. and it's, fairly respectable, or respectable at least, to have some humanity, some human character to it, some wit or whatever, right? So blatantly, the rejections that they're doing, right, are just unfounded. But their policies that they're not even going to enter into any debate or discussion about it, yet they're wanting to put suggestions. Now, the suggestions themselves, I don't think they're lawful. Because firstly, if you need help with spelling and grammar, and if you can't write to an extent where no one can read what you're saying, which they're saying that they can't understand what you're asking, but that's just them being stupid, right? They need to, what do they do on a website if they can't understand it? What happens if it's a really technical mathematical equation? They go ask someone who does, right? So, I think that they are understandable, and I think they're lying and making it up. They're trying to. They do understand it, because when they replied to your email and give you a suggestion, they read it, they knew what you're asking, and they reformulated it. So what they're actually doing is they're lying. They did understand what you were asking for, right? And they don't want you to ask for it like that. And that is beyond grammar and spelling. This is like a new thing. This is like, I'm going to tell you how you should talk and what you should say, right? And that is not a prayer, right? And that is not a legal statement. In law, in criminal law and civil law, you cannot tell someone what statement to write, or change it or alter it, or even suggest that they should write something else, right? Maybe the solicitor might advise a person that, if we want to win this case, maybe you should, not say this or that, right? But that's an advice from a lawyer, and that's privilege, by the way. That's a privileged communication between a lawyer and his client, by the way, outside of court as well. It could be at the solicitor's office or whatever, at your house, right? And the prosecution and police can't use that. So, but they're going beyond that now. They're going into this like AI predictive text, and as you're typing on Google, it's trying to tell you what words to use, and that is, they're trying to formulate your argument for you. And the whole point of a claim or a legal challenge is you yourself trying to be clever and thinking up of a point, idea, question, or something that can win an argument and beat someone else, right? Which is what barristers do, right? But in Parliament, you're trying to beat the Labour Party or the Conservatives or Jamie Stone, right? And they don't want to be Jacob Rees-Mogg, this select committee. They don't want to be beaten. And they've come up with this policy whereby they have formulated a policy agreement whereby they are allowed to beat you before you can't even have a fair chance of beating them. They don't want to debate it. They won't officially debate it. It's not allowed into the debate. They can block you from the debate, right? And for any reason or no reason, and repeatedly do it, right? That is not parley. That is not a two-way conversation, right? That is, and they're trying to formulate your policies. This is what Labour do with their members. And I am not a member of the Labour Party. And this is what the Tories do. They're treating us like they treat their own MP members. If you don't vote their way in the chamber, they throw you out of the party. And if you don't submit petitions that are to their liking, then they reject them on any reason or no reason, and there's no debate or discussion over it, right? So it's the partisan dream. It's the partisan fantasy, right? And what this is, it's like the Labour Party and the Tories shaking hands and coming up with the partisan agreement deal, the penultimate agreement, right? The Conservative and Labour union, the partisan dream policy against all independent challengers who don't vote for their parties and who can't stand them and who want to get them out, right? Particularly getting their forfeiture, removed or whatever. And the thing is, the title of the paper, right, is a collaborative system. E-petitions a collaborative system. And what it actually is the Tories and Labour collaborating against us. It's Jacob Rees-Mogg and his crony crew collaborating against us to protect their privileges and reinforce protecting their honours and completely stealing and undermining our privileges and even trying to edit, manipulate, change and suggest our own prayers and statements against them. It would be like the Crown Prosecution Service being able to come up with your defence package, right? Not the court, the prosecution. It is pure, absolute partisan overdrive. It is partisan overdrive on steroids. It is pure partisan overdrive on steroids, right? And this is what the new paradigm is. And this is what they did in the pandemic. It is political parties completely and totally dominating us with complete misleading lies about the law and rights. And worse than that, we didn't even elect the staff who are doing this to us. And it's not law. It's a policy agreement between two MPs. It hasn't been put through the House of Lords. So it's not even the law of England. I wouldn't consent, submit and accept to it. And I'm not, because it's not lawful. It is contemptuous and illegal. And further to that, Mogg has cheated in the elections and he's giving entertainment over GB News. And Ofcom, or the Committee for Media and Sport, will not do anything to remove him. Even though he won his case in the High Court, but that was civil. It wasn't a criminal charge. So they've created a juggernaut, a little tiny committee, which is almost impenetrable, but not. It wasn't even made in the law. It's an agreement that no one would agree to in their right mind. So that is why it needs to be sorted out, and that is why we need the privileges affirming. And effectively, right, the privileges apply through the Constitution, no matter what. They are immediately applicable in law when you're doing petitioning, right? But what Mogg and crew are saying in their paper is that they're advising against acknowledging or affirming privileges for e-petitioners. That's what they're doing. They're trying to persuade and argue that the staff of the Petitions Committee and the Petitions Committee members, the MPs on Parliament, should not acknowledge or affirm our privileges if we need them to be affirmed, right? And it's in the manual of procedure under petitions. It exists, grievances over privileges when they need to be claimed or where there's a contempt, or, you know, so, and it's in Erskine May. So they're denying us process, and it's meant to be recognised by the courts anyway. But you would have a court order, you know, in 1984, 1950, 1920. If it was going to be a big petition, the court would stamp your petitions. The court would put this court consent on it. And you will get it granted anyway, you know, and that's to do with canvassing and the law of agency. So, you know, and this is why Speaker Lindsay is refusing to give us the certificate. This is why Speaker Lindsay will not give us the certificate when we've got a complaint, a grievance over privilege, and we need it for affirmation in the courts, because Mogg and this committee have tried to put a persuasive argument that, you know, we shouldn't have it, or that it doesn't apply. What? Yeah, why is it in the paper? It's got not. If it's got nothing to do with it, why is there 2 pages of it in there? It's just pathetic. It's the most pathetic argument ever. It's the worst, it's the most flimsy claim that anyone could ever make. That paper's so terrible that, an entire paragraph on utilising every single committee, making the full use of the full spectrum of all government, and at the end is, but we don't want anybody to, about honours or whatever, but we won't actually say that, because there's a committee of forfeitures, right? So, and I don't think that they actually want the people to be able to invest their power into honours. Have you noticed all the honours now are given out by the Prime Minister or the government? And you can sort of make applications and recommendations. There is a set process. It's meant to be an electoral process, though. It's meant to be like, elected knights. So the origins of it is electoral. And petitions is a citizen-based process. It's electoral register. It's the Representation of the People Act. All the juries now come off the Representation of the People Act, right? From the electoral register. So they don't actually want the people to decide who should get honours and so forth. Well, we vote them in as MPs, but it seems like they are taking control, particularly over, who gets into the House of Lords and so forth. But, it's when persons are not performing or when they've done something wrong, we do have the right to have them removed, and they're trying to obstruct and block that. So, it's the biggest contradiction in that paper. Why don't they just write in the section, right? We want you to make full use of the government and all committees except the Forfeiture Committee. He doesn't want you really... What Mog's doing is, and his cronies, is that they talk about committees, but then when they mention honours at the end, they don't say Forfeiture Committee, because then, we can't have any, things about honours, but I won't write that, so therefore you can't petition the Forfeiture Committee. Oh, there is one. Yeah, like I said earlier, you can petition about any committee, right? But we don't want you to do honours, right? But it's a committee. Oh, is it? Yeah, you said any committee, right? Well, but not that one. Well, why do you have to do that elaborate ending? Why the elaborate ending? Why the, but don't do any, we can't accept any petitions about honours, right? It's like the start of it, the big title with the coat of arms on and all the, the decorations around the start of the act, or whether, at the end, this, we can't have any matters of honours. But why don't you just say that in the paragraph about, we want you to use the full spectrum of the entire government and all committees except the privileges, except the Honours Committee, right? Why don't you say that? Why this elaborate ending, like, honours, no honours, no honours, Why don't you just put, we want you to use, we don't want you to use all of the government and committees which are available, because there are some which we rather you keep away from, like our honours and our privileges, by the way, because you don't have one, then we do, because I'm Rees Morgan, I'm talking the truth, I'm not a complete and total criminal, and I didn't actually give entertainment to people on GB News in order to try and get elected, but I lost, this is the thing, we need to, these MPs need to be brought to justice, and we've even lost the ability to hold them to account in Parliament. There are no impeachments or anything like that anymore, and that's why they're getting away with it, and all they do if they do wrong is they just stand down. So, and I'm not talking about criminal charges that are in their own personal life, like Dan Norris and, Mike Amesbury and people like that, who it's a criminal thing. It's nothing to do with, what is done in Parliament. But they're meant to be elected and represent their constituents and turn up in Parliament, and they're not even getting their privileges acknowledged properly to the rule of law. So if these MPs can't even stand up for themselves, like Suella Braverman and people like that, then how can we expect them to stand up for us? Is it just that, clearly they don't even know their own rights properly, some of them, so how can they be expected to know our rights properly? Or Are they acting contemptuously? I would suggest that Jacob Rees-Mogg was acting contemptuously because they're really going out of their way to try and protect their own interests, like, honours, and not acting in our best interests. So, how can you even facilitate and protect the process it's meant to be a protected process, that's the thing, that cannot be intervened in or obstructed, and they're wanting to make it so it can be intervened in and obstructed, because I think the basis is this, right? If they're just going to reject the petition anyway, right, then it's worthless. If they can just reject it on anything, right, they can reject it on any reason or no reason, right, for whatever they nitpick on it, right, and you can't even object or contest that at all whatsoever, right, then it's just nothing. It's got no value or no potential value. It's just nothing. It's not your prayer. It's not your official legal statement. It's just valueless. It's actually a fleck. It's worth nothing. So it's not even worth. We don't deserve privileges, right? It can be rejected on any reason or no reason, with no argument, no debate, no dispute, right? It's just flick. It's like thick, like that. It's just flick, like that, right? So why would they go to the trouble of all these elaborate privileges if it's just worth nothing? If it's just absolutely nothing, it's just fleck, like that, right? Any reason or no reason, fleck. It's worthless. It's got no value at all. So it's not worthy of privilege because it's got no respect, value, or potency of itself, because they can just reject it for any reason or no reason, and they don't have to justify it or explain themselves at all. And that's really why the Clerk of the Parliament really was stopped from these private bills, and because they were making a lucrative business out of it, and it was ending up being not fair, unfair, So, we're past these people intervening in, you've got a legal right to collect, you've got a lawful right to spread awareness of it and collect the public support behind it to pressure the government into acting. And that, I think that's what the privileges protects. It's the capability, it's protecting and enforcing the capability to communicate it and collect it, demonstrate a strong, compelling power, force. And unfortunately, it's the Petitions Committee who are demonstrating compelling power and force to obstruct and block and hinder and disregard and so forth. But we're the ones who are saying, no, well, it's not respectful or this or that. Well, a lot of things that the Mayor of London has just fined everyone hundreds of thousands of pounds that people can't possibly afford or pay for, and force their vehicles from them, right? They're going through hell, financial hell. And they're very angry, but apparently he can do that because he's the mayor. He gives him the right to do it, but he doesn't think that they should be able to, complain and shout and scream to tell him to stop doing it, right? Equally to oppose it, and cause him equal, justifiable inconvenience, which was anything to amount to what is a cost to them. He doesn't think that they've got a legal right to do that, right? And that's the difference. That's why, everyone's just the mayor is just literally, like that. Because, we don't have any, apparently we don't have any rights when we do. So, but that's supposed to be only really mainly concentrating on the clerk and the Petitions Committee staff. It's a dynamic. It's been, what they've done is they've taken some standing orders and resolutions, right? And they meant a certain thing, right? And what they've done is they've given themselves poetic license to kind of elaborate them into these kind of like any reason or no reason type things, and then even giving themselves the right to dictate. What they're actually doing is that they are trying to basically, it's like possession, So, like in The Exorcist, right? They're trying to possess you, and taint your prayer, effectively. They're not just trying to correct you or correct your spelling or assist you or whatever. They're actually, it's a tainting, and they're actually trying to change any barrister, right, worth any of his money, any technical or precise barrister who can win a case is renowned for doing it on his exact choice of words, his exact line of questioning, how he wants the question to be pronounced, or how he wants the question to be heard. It's an art form, right? And in these petitions, it's a political art form, and it doesn't have to be swearing or whatever to make a point, to wit. And they're trying to take that off you. They're trying to take that edge off you because it's got a political sharpness and potency to it, which can win. And what they're doing is they're filing it off. They're trying to file it off and file it off and file it off for reasons really why it's too good, or it's good, it's strong, right? And this is the handshake of the collaborative partisan covenant which they've got against us, which is, this is good for us. Any reason or no reason, we'll create a new privilege for these staff. They don't have to answer questions, they don't have to explain why they rejected something or whatever. They don't even have to enter into any debate, they can just repeatedly do it. And if if they're not accountable to the ombudsman, who are they accountable to, right? Who are they accountable to? So, we need a resolution for it, for sure. They're not even giving us any support or assistance with our websites and things like that. It's as if, you're doing a legal case, but you've got no legal support at all from the court, And if it was too big for them to take on, they shouldn't have done it in the first place. Tony Blair shouldn't have done it e-petition site if it was too big for him to take on. If you look at the figures that I've put the figures here, which are showing how many petitions the government was receiving, right, from, they said from 1987 or 1989, but actually they put a spelling mistake on it. It's actually from, I think it was from like the early 90s until 2007. And it's only like, sometimes they didn't even get 100. And sometimes they got 230. But it doesn't amount to within 5 or 10 years, really more than 1,000. So for the whole country of England, of 60 million people, it's a very small number of cases, and out of those, few of them are that bothered or concerned about privileges, because usually they don't need them, right? It's certainly when people are testing the boundaries of it, like when you had problems with the Luddites and with the suffragettes and so forth. But that comes with the political climate, and what you've got now is like in the 1800s when you had this massive sharp increase and spike in petitions. We've got that now because of all those pressing issues, and that is when the people need their rights and privileges, that's when you need them. And unfortunately, when you need them and when you need it now, it's been denied. And that is what the contempt is against the Constitution. When people are really needing them, they're not there, because we're being denied them, and that's when people are ending up getting in prison now and so forth. So it needs to be sorted out very quickly, and they exist, and that procedure to claim it is correct and right. And I think the Parliamentary Papers Act definitely, when it's published on the website, Rees-Mogg, what he's doing is, it's a persuasive argument. It's not based on law, his argument. He's not coming up with any examples of legislation or an act or whatever. It's purely these 12 committee members, their belief and opinion, and a persuasive argument. And that is nothing more than that. It's a persuasive argument that they're trying to get you to believe something, and they're not actually putting any legislation or acts or law to support their claims at all, right? And they're just saying that we don't think that you should have this or that. And that's purely it. And, to say that you come up with a policy, and that actually, I don't think that is actually in the policy clauses, to be honest. I don't think that got into the policy clauses. If it is, you can show me where it is, but it's only in the paper, right? It's only like a proposition in the paper, right? So Lindsay Hoyle, there is actually there's nothing in law, in standing order or statute instrument to say that we can't claim privileges for e-petitions. Nothing. In fact, if you go by the manual of procedure in the public business, it's there. The claim's there. The process is there for it. It exists, right? And they're trying to convince us that we can't have it when they're wrong. And that's what it comes down to. And that's bad enough with them also setting up a system by which they're not accountable. You can't have a government department that is not accountable for what it does. Like if they say, "Oh, I'm removing this because we can't do this or that," but when they evidently can, then they're not accountable for what they're doing. And this is when the worst abuses of privileges happen. They're actually abusing them, probably, worse than, because that's actually causing people to need to do these protests more and more. And that's why Extinction Rebellion aren't getting any joy through the government. So they're having to resort to trying to spread the awareness about it and do all these publicity stunts to get more support from the public, to put more pressure on the government. So what the Petitions Committee is doing is it is actually causing, it is the feedback cause for all these problems, and then they're just trying to put more legislation through which criminalises it when it can't possibly be criminalised on the legal basis of law, because it's a jurisdictional argument, not a common law argument. It's not in the common law. You're seeking the common consent from the people. It's not in the common law because you're already collecting the signatures of the electors, so it's not in the jury's court really. And then that's the problem.